And on that point, my lord, that concludes the leading of the evidence for the state.
Okay.
And we close the state case. It's precisely 3 years since the state started leading evidence, and the state now formally closes its case.
State case closed. Yes. Yes.
Kimba labashushisi-ke lapho likhuluma phecelezi nodaba lemibukiso-ke imibukiso yonkana kade beyilethile ngaphambi kwenkosi yenkantolo-ke ukuthi ihamba kanjani list yakhona-ke manje bathi baqedile-ke ngecala labo-ke manje-ke ngemuva kweminyaka-ke emithathu besolo beqhuba-ke icala labo lokuthi babizeke abofakazi bafike bathi ufakazi babo manje athi baqedile-ke ubiza abofakazi futhi uqedile ngecala labo.
Yes, Mr. Mnisi.
As it please the court, my lord, I thought I would have brought the following to the attention of the court even before the state closes this case. Number one, it relates to the video clip that Mr. Bailey had to come and give his testimony on. That video clip has already been admitted as evidence before court, and it was on the proviso that Mr. Bailey would come and authenticate it. Now, the court has been told yesterday in no uncertain terms that Mr. Bailey is no longer available to come and testify, and not because he's dead, but because of the agreement that the state and SANEF, South African National Editors Forum, an institution that Mr. Bailey belongs to, that he should no longer come testify because Mr. Bailey and company indicated that if he were to be forced and dragged, come to court, come testify, they will bring an agent application to bar the state from forcing him to come testify because of the standing agreement between SANEF and the National Prosecuting Authority of South Africa. So as we stand now, or as things stand now, and as at this point in time, that video clip remains unauthenticated. I thought to myself that, and in fact, Mr. Bailey had indicated in an affidavit that was read into record here, where he says that when this whole thing was taken, when this video was taken, I wasn't party there too. I was in China. So I don't know who took it, when was it taken. I only got requested to provide, as a head, to provide a recording of a video that was aired on the 27th of October 2014, which I did. But as to the finer details and the integrities around that video, I don't know nothing. So if the state proceeds to force me to come testify, I will have no option but to challenge the legality, and that is what the state was avoiding in that agent application. The legality of Section 179 of the Criminal Procedure Act that seeks to deal with the subpoenaing of journalists to come and give information where the state seeks to use the content of their information. But fast forward, my lord, we are saying it's not like all the state avenues have been exhausted. Well, I do not intend to prescribe how should the state proceed with their case or drive their case. But Mr. Longwe is there. If they still want to pursue that video, they can simply say to the defense, no, don't worry, our avenues are not exhausted. Mr. Longwe, who's depicted in that video, is there, he's still alive. He can come himself and authenticate that video. But it seems to me like the state is not amenable to follow that route. So that video being part of this record, my lord, and not being authenticated as promised by the state in the manner in which it should have no longer be that is actually part of the record. I'm not saying that it must be withdrawn. In other words, it's just a pro non scripto. It's regarded as not being existing. That was just point number one, my lord. Now, point number two, on number of occasions, Mr. Sibia has been requesting that certain information, actually the records regarding the movement of the motor vehicles that were used on the day on which he got arrested should be made available to him. I must be honest to the state, they made some endeavors to identify certain motor vehicle. There was a hard body that was involved there. They gave an explanation about the hard body that ultimately was involved in an accident wherein Mr. Mapena passed on. There was a Golf 7. There was also an explanation regarding or around that Golf 7 that it was not fitted with an AVL gadget. There was a hatchback. I think there was also a BMW that was driven by Mr. Buthelezi from Eguruleni Metropolis. There was an explanation from Eguruleni Police that motor vehicles from Eguruleni Police were not fitted then with AVL records. Much against what there's a gentleman used to sit. Much against what Mr. Listering said, that yes, they are indeed fitted, but we're talking in 2020 when Mr. Sibia was arrested. But that's an affidavit that we received from Eguruleni Metropolis to the effect that their motor vehicles are not fitted with AVL gadgets. Now, Mr. Sibia keeps on hammering on a Qashqai, a silver Qashqai motor vehicle, and he consistently maintained that it was driven by Mr. Ngamani. Ngamani, I think it's a totem of Mr. Masego, but he says they used to call him Ngamani. Even the investigating team itself referred to him as Ngamani. We have got no explanation on the request relating to this Qashqai motor vehicle, my lord. And there is also a Ford Ranger that was allegedly also involved when he got arrested. And it was driven by a gentleman known as Bongani Yende. We haven't got an explanation on whether or not we ultimately received the AVL records relating to this motor vehicles, my lord. May I again confirm with Mr. Sibia if there's something that I'm missing, my lord, so that I also place it on record, my lord. Thank you. Thank you, my lord, for the indulgence. Yes, the information that I've placed on record is accurate. That Ford Ranger that I'm saying was used by Bongani Yende. Bongani Yende was also a member of the South African Police Services, my lord. And the reason why we are requesting this information, my lord, we are well aware that the state has got no obligation to assist the accused in the conduct of his defense. State cannot get out of his way and go out and get information in favor of the accused and say, accused, this information, you can come and challenge our assertion against you therewith. But this information is different, my lord. It is information that is in the domain of the South African Police Services. There is nowhere else where we can go and request this information but from the police themselves. So we constrained because we cannot go to people and say, can you please give us this information? The only people from which this information should be received and must come from, if this information is available, are members of the South African Police Services. Which is the reason why we're requesting the state to kindly furnish us with this information if they are able. If they are not able, then they are not able, my lord. That was point number 2. Now, point number 3, my lord. Now that the state has closed its case, normally at this point in time, the defense has got options. It either says, we are going to testify, or we want to bring an application in terms of Section 174 of the Criminal Procedure Act. Now, we had a, when I say we, I'm speaking on behalf of accused number 1 and 3. We spoke to the Legal Aid South Africa just a second, my lord. There's something that I need to clear with my colleagues.
I just have a word with my colleague.
Thank you.
What's happening? Mr. Meyiwa, have you closed your case?
Yes.
Yes, indeed, my lord.
What does the law say? Once you've closed your case?
Well, once we've closed our case, then that is the turn of the defense to present their case. And they have various options as far as that is concerned, my lord.
Thank you for the indulgence, my lord. I'm requested by my colleague that we should give the state an opportunity to respond to the issue relating to the video, whether they are still pursuing it or what, my lord. Thank you.
Yes.
Well, as the court pleases, my lord, we will respond to, even if we don't have to at this stage, but my lord, it is correct. At the time when we handed up Exhibit 8, we intimated that we intended to call Mr. Bailey, and we requested that the Hearsay Act be applied, that the evidence regarding the video be provisionally allowed, subject to the state calling Mr. Bailey. And we indicated yesterday that Mr. Bailey is no longer available. But the video footage, my lord, still qualifies as a real exhibit. I think that was the point that was made by Mr. Ramosepele in his argument, that it still qualifies as a real exhibit. And my lord, for a real exhibit to be admitted as evidence, it only needs to meet 2 criteria. The first one is that it must be relevant. And the second one is the issue of the weight to be attached thereto. And the first hurdle, my lord, that the state needs to go over its relevance. And we have argued relevance, my lord. We have indicated that the purpose of ending up the video footage was to deal with a proposition that was made by the now late representative of accused number 1, when he cross-examined the ballistic expert, Lieutenant Colonel Mangena, during the proceedings of the 28th of August 2024, in lines 19 to 25. We've already made the submissions, my lord, but we'll rehash those submissions. Mr. Mgomezulu made the following proposition. He said, all right, let me put this version to you. According to the witnesses that I do not want to disclose at this stage, 3 shots were fired. 1 shot is the one that caused injury to Zandi. The other shot is the one that Longwe Twala shot himself on the leg while they were struggling for the gun. The third shot is the one that shot Mr. Senzo Meyiwa. And on page 12, lines 2 to 3, he says the one was stuck in the ankle of Mr. Longwe Twala, and the other one is the one that shot the deceased dead. So, my lord, we handed up that the footage to deal with this proposition, and as I mentioned, my lord, that the footage does qualify as real evidence, and all that the state needs to show for the admission of real evidence is that it is relevant. The other inquiry that I mentioned is the weight to be attached to the real exhibit, and that is the issue that will be argued at the end of the case as we demonstrated. So the only hurdle that we had to go over at this stage is to show relevance, and we have shown how this video footage is relevant. As to the weight to be attached there to, it's what will be argued at the end of the case. So what Advocate Mnisi submitted, that it should be the evidence should be regarded as pro non scriptura, cannot go up. The video clip, as I said, my lord, qualifies as real evidence. The investigating officer has testified, Brigadier Gidinda. He has identified the person that is depicted thereon as Mr. Longwe Twala. What was now left was the state to show the origin of that video footage, and yesterday, my lord, we were at pains to show a series of correspondence that related to the Section 205 application for the video footage, pursuant to which, my lord, the video footage was then handed up to the state, and the court will recall that from the correspondence, it was clearly stated that the information that is requested is video footage that pertains to the events on the 27th of October 2014 at the house of the Kumalos, and the video footage was then released by ENCA pursuant to that Section 205. My lord, we don't want to present a full-on argument, but even the authorities, the handbooks And we briefly going to refer to the handbook by the well-known authors Hoffman and Zeffert, South African Law of Evidence, 3rd edition, page 313, who distinguish between documentary evidence and real evidence, and refer to real evidence as consisting of things that can be examined by the court as means of proof. And as we've indicated, my lord, that the footage qualifies as real evidence. The court has examined that during the time when we showed the clip. The learned authors go on to say that the court is entitled to not only look at the article produced as real evidence, but is able to listen to, smell, taste, or feel it. The court is entitled to rely on its own perceptions in observing the produced article. Hence, we're making the submission, my lord, that it does qualify as real evidence. My lord, as far back as 1996, in the case of State versus Mpumlo and others, it's 1986, volume 3, SA 482 is the Eastern Cape Division decision at 487, paragraph C to D. The court held as follows: a videotape, motion picture, or photograph may be authenticated or verified under oath by 1. the photographer or camera operator, B. a person present when evidence was recorded, film or photograph, C. a person qualifies to state that the representation is accurate. We called the investigating officer who testified that the person shown on the depicted on the video footage is Ms. Longetwala, and the third requirement is that an expert can also be called to testify about the operation of the equipment. For instance, automatic surveillance camera, who is called to authenticate a videotape, and the court held that the authentication goes to the weight to be attached, not admissibility. And we submit, my lord, that the argument that is being presented now conflates admissibility and weight. Admissibility depends on relevance, which, my lord, we have already argued. There were other cases as well, my lord. The well-known case of State versus Baleka that Mr. Ramusipili referred to. The 1986 volume 4 SA 1005 is the decision of the then Transvaal Provincial Division at 1026B, paragraphs B to C, where the court held as follows, and we quote: I deal with tape recordings as I would deal with any other type of real evidence. The test is whether it is relevant. It will be relevant if it has probative value. It will only have probative value if it's linked to the issues to be decided. My lord, we've already argued that this proposition has been made, and this video footage deals precisely with that. So we've made the submission, my lord, that it is relevant. It therefore passed muster for relevance. The only issue will then be admissibility that will be, weight. The weight to be attached thereto that will be determined at the at the end of the presentation of the evidence. And the court went on to hold that that The link will often have to be supplied by evidence of identification of voices on the tape, where the identity of the speaker is in issue. As we've already indicated, my lord, the investigating officer has already identified the person on the video clip. What was left was for the state to establish the origin, and that we submit, my lord, through the presentation of the various correspondence yesterday. We showed in our argument how the state happened to be in possession of the video footage. These decisions were confirmed in the other case of Mutata vs. Naya, NO, and another. 2009, Volume 1, SACR 263, and is the decision of the Gauteng Provincial Division. So, my lord, in a nutshell, we are saying the video footage qualifies as real evidence, and all that the state has to prove is relevance. We've already argued, made the distinction between the facts that are used to prove the facts that are in issue, and the facts that we made that distinction, my lord, that the facts that are in dispute and the facts that are used to prove those facts that are in dispute. So the videotape is will qualify as evidence that is used to prove the facts that are in dispute, namely that proposition that was made. As indicated, my lord, even if we didn't have to argue the point now, in light of the submissions of Advocate Mnisi, we make the submission, my lord, that that evidence cannot be regarded as non-proscriptive, as the court places.
But the other thing is the evidence of, is that Bailey, is it before court?
Well, the evidence, no, it's not before court, my lord.
Yeah.
Yes.
Saying he's going to China, he's going to what?
Yes. No, that's not before court, my lord. Yes.
Yeah, okay. Otherwise you have closed your case.
Yes, I've closed my case.
And what the law, as I understand it, once you have closed your case, Mr. Mnisi can argue
At the end of it.
at the end of it.
As a court.
Yes, Mr. Mnisi. That's it.
As far as the other issues that you've raised of the cars, the Nishan Qashqai and the affidavit of Mr. Bongani Yende, that we've already addressed. They are also at liberty to subpoena any witnesses to testify in their favor.
Okay.
Thank you, my lord. I'll definitely argue at the end of it all around this video. Another point that I would need clarity on. The state had been indicating in the course of the leading of its evidence that it would not be calling certain witnesses. Those witnesses will be made available to the defense. Now, I want to, actually this is just a re-emphasis that from this point onward, in other words, henceforth, the defense is now in liberty to consult with whoever's name appears in the list of the state witnesses if circumstances were to arise. I just want to confirm if my understanding in that regard is correct, my lord.
As a court, my lord, the law is very clear that any witnesses who is not called by the state is at the disposal of the defense, and that will obtain here. We make all witnesses that haven't been called to we make them available to the disposal of the defense, my lord.
Thank you, my lord. I'm going to request just a very short adjournment so that I come with a response on the way forward, my lord. Those were just the preliminary issues that would still have affected the state, but now that they've been ironed out, it's fine. The state is no longer involved henceforth, my lord, except for cross-examining witnesses in an event that they will come to that level, my lord, or to that point.
Hardly 12:30.
So when should I come back?
My lord, if I can...
We can come back at 2, my lord.
2 o'clock.
Yes.
Okay, 2 o'clock then.